CONSULEGIS. I would like to welcome everybody to the second CONSULEGIS live webinar. Now I want to introduce you to our moderator and speaker, Jeffery Daar. Jeffrey?
Hello, everybody. Welcome to our webinar on how to avoid and manage disputes in international transactions. This is being presented by the CONSULEGIS International Litigation and Arbitration Specialist Group. I am a lawyer in Los Angeles. I'm a principal of the law firm of Daar & Newman. I've been practicing commercial litigation for over 30 years. I've been having as an additional specialty international disputes and transactions for more than 20 years, and I'm one of the co-chairs of the International Litigation and Arbitration Specialist Group of CONSULEGIS. I also like to introduce our second speaker, in addition to myself, which is Peter Kaye. Peter is my co-chair of the International Litigation and Arbitration Specialist Group. Peter is a partner and head of commercial dispute resolution at the law firm Linder LLP in Manchester, United Kingdom. And Peter has commercial litigation experience for over 30 years. And our third speaker joining us today is Diego Zavala, who is a partner at Mersan Law in Paraguay. He is also the editor of the newsletter for the International Litigation and Arbitration Specialist Group, and Diego has 20 years of commercial litigation plus background. Very briefly, there we go. You'll see there's some slides here on some background information about CONSULEGIS. For those who are not familiar with CONSULEGIS, we are an international network of professional independent law firms and in-house lawyers. The network comprises over 1,700 lawyers. We have members in more than 45 countries and more than 150 cities around the world. CONSULEGIS has a number of different practice groups within it. And you'll see that in addition to the International Litigation Arbitration Specialist Group, there's a number of other specialist group areas. We also have regional groups and a young lawyers group and a business generation development group. There's additional information, and the other thing before we get into the substance of today's webinar, we are managed in Munich by our Managing Director, Anke Braun, who started the webinar today. A little bit about the CONSULEGIS International Litigation Arbitration Specialist Group, who's putting on today's webinar. We have lawyers in more than 40 countries. In addition to what's on the slide in front of everyone, we were able to put together teams of lawyers as needed for cross-border disputes and avoiding of disputes and assistance on structuring transactions, as we'll be going over, so they work in the event that there is a dispute, or how to avoid the dispute from ever making the deal fall apart. And we also have information on the detailed practice areas of our member firms. So starting with the substance of today. Today's webinar will provide you with an overview of the issues that you should be aware of when you are conducting business that is cross-border, more than one country, so that your transaction and business will work as intended and contemplated by each side. And as we'll go through the issues, of course, there may be one side who wants to make sure the deal stays together. There may be another side that really doesn't want to be held accountable. And because of the added dimension of more than one country involved, we'll be going over what is an international transaction first. And basically, it could be any type of business that is cross-border among one or more countries in addition to one primary country. So it could be 2 countries, 3 countries, could be different regions of the world. It could be over goods, could be over services, virtually anything. And what we're hoping is that what everyone will take away from today's webinar is enough of the basic issues to be aware of so that when you are involved in putting together an international transaction, you'll know when you spot these issues to make sure that you pause and address them so that your transaction will work the way you intended it should work. Very quickly, a starting point for everyone, and we'll start with sort of a worst case scenario of you have your transaction, you've inked it, everyone has signed it, hopefully it's been put together correctly, and we're going to hopefully avoid these types of problems. What happens, of course, when you have disputes arise early in the contract? Will everyone think they'll be held accountable? Will they want to be held accountable? Will the contract be clear as to what is everyone's obligations under the agreement? Will it be clear as to language? Will language even be clear if it's the same language but to people in different countries? What happens if there is a dispute that goes to a court or an arbitration? And what will happen if that happens, we'll be covering. How much will this all cost? And at the end of the day, will people know going into the transaction or as a dispute arises whether they'll be held accountable? Because if a judge is involved someplace through a court system, whether the resulting judgment would ever be enforceable where the other party is located or may have assets, or whether if it's an arbitration, people will be held accountable and it'll be recognized and enforced, we'll be covering. And so the worst case scenario would be none of these things are going right. There's a dispute, everybody's obligations are not clear, what language controls or law controls is not clear. It's not clear what happens if you have proceedings being brought in multiple different countries. It's becoming very, very expensive with no end in sight. And no one even knows at the end of the day whether or not if somebody is successful, they'll even get recognition and enforcement of a resulting judgment. So we're going to hopefully address these issues so that that won't be your scenario when you have an international transaction. Peter.
Right, this is where I come in. So from my point of view, what can you do? This topic is how to avoid and manage disputes. So the starting point must be trying to avoid any dispute in the first place. As it says on the slide, prevention rather than cure. This should always be in your mind when you are entering into any contractual relationships. Everyone believes that when they enter into a contract that nothing will go wrong, but the reality is often very different. This is the experience of us lawyers. If you take care and prepare properly at the outset, you will save a lot of stress, anxiety, and of course cost further down the line. The contractual terms entered into at the outset is your opportunity to ensure that you protect yourself as best you can, and you, together with your lawyers, should be thinking about what could go wrong and what steps you should be thinking about. Don't leave it to chance. It will certainly be costly further down the line. So moving on to the next slide, preliminary considerations. If you're looking to trade or contract with other organizations in foreign countries, it is likely the implications or contractual terms will not be fully understood. Again, don't leave it to chance. You should find out what legal issues could arise, and the way to do this will be for your own CONSULEGIS lawyers to contact their colleagues in the other jurisdictions who can assist and advise. It is essential that your own team or lawyer has expertise in dealing with international transactions, and you should just not assume that they will. The starting point is to question your lawyer. Ask them specifically what experience they've had. If necessary, get recommendations. CONSULEGIS lawyers are experienced in cross-border issues, and there is a wealth of experience within the network, or there certainly should be. In considering the terms of your contract, make sure that you give consideration to how disputes could be resolved if problems arise, and that they are considered at the very earliest stages of the negotiating and drafting process. Once again, it is always far harder to deal with these problems and issues retrospectively. Whilst you are always thinking about the benefit that the contract will bring, you should not ignore strategies which may become important if a dispute arises. Probably you should carefully consider who has the greatest bargaining strength in the negotiating process. If you believe that you have the greater bargaining strength, then you could perhaps impose favourable terms favourable to you. If on the other hand, you are in the weaker position, make sure you fully understand and are prepared to accept terms imposed on you, particularly if it may mean that the disputes will be resolved in jurisdictions that you are not familiar with and perhaps with different legal systems. Diego, I think this is where you will come in.
Well, actually, this is Jeff. I'm just going to make a quick comment that my experience is that, unfortunately, almost always the concept of bringing dispute resolution issues into the early stages of negotiating is not what happens. It's usually the afterthought after all the deal points are made, and therefore there's little bargaining leverage left for anyone on the key points of what will probably keep the deal alive and make it work as everyone intends, which is all the points we'll be covering. And so my experience is this is the biggest issue that no one does correctly, which is you bring in the lawyers to help you make sure that your contract is clear as to how it will work and be enforceable if that's what you want, or if you don't want to be held accountable to make it less enforceable. But that happens as an afterthought, and then you bring in people who aren't familiar with the real nuances of how this will play out around the world, and they will just take whatever boilerplate type language was in some other contract they may or may not have done themselves and just assume, like a cookie cutter approach, that it'll work in the same in every transaction. And hopefully you'll get from the flavor of our webinar that that's actually the last thing you want to do. Every transaction is different. Every transaction has its own nuances, has its own cultures, languages, issues to deal with, and what you want to get out of the contract to each side may be completely different from whatever other international transaction you had before.
Yeah. Hello, everybody. This is Diego Zavala speaking here from Paraguay. So my next slide is about the basic contract consideration that you should take care of. First, you should consider possible ambiguities with international dimension of a transaction. Here, the differences of languages and cultural perceptions bring a great deal of problems, especially if you are not a native speaker. And if we are speaking about international transactions, you should consider that the other guy who is going to be in the other end of the deal, possible would be, or most sure, would not be a native speaker. So in this case, or in this scenario, you have to have a great deal of patience. Drafter of contracts, in this case, since they are not native speakers, you have to be very attentive and listen to their considerations. And if they are speaking especially if you are speaking in legal terms, sometimes legal terms here, or for example, let's say in South America and Paraguay, would not be maybe the same in other parts of the world. So you have to be very careful, be very patient, attentive, listen to what they say, and of course, that will bring you a lot of perspective in order to clear the aspects of the international transaction, to clear the issues. Second, to take the necessary time to make the contract clear for international aspects. First, make sure that your interests are clearly stated in the contract. What helped me a lot, especially in big contracts or in very extensive contracts, is to have a term sheet very clear where you state your issues. Take time here, discuss thoroughly your intentions, or state your intentions very clear in a term sheet, and that will help you a lot going through the development of the contract. Second, it's very helpful when you take the necessary time that the issues that you are considering are very thoroughly considered, discussed and reflected in the agreement. And if you are speaking about delivery of goods, for example, it's very important that you consider the allocation of risk. In this case, what helped me a lot is bringing to the table or using the ICC rules for interpretation of trade terms. That helps people in different ends of the world about interpreting the trade terms. That makes very easy. Third, avoid tendency for deal makers to rush the deal and shortcut the process. Don't do that. That, of course, will lead to mistakes or misunderstandings, and you will advance in the contract with that misunderstanding, and it's very difficult to go back in the contract and try to clear some aspects where you are already advanced. The next slide, please, Jeff. Language issues, that is a thing that concerns me a lot since I'm not a native speaker. One or more language in the contract. This is not recommendable. Try to avoid by adopting one lingua franca, what we call lingua franca, a common language that is used by everybody in trade or in commerce. In this case, in this part of South America, as in most part of Latin America, we use English as the lingua franca, or the common language for our commerce and our trade. Try to adopt that, and that will make things speedy and easier during the transaction. Problems of two languages. That will bring, I mean, if you keep on and try to use two languages in the development of the contract, that will bring you a lot of trouble. Starting with the translations. You have to explain the translator what is the meaning that you are trying to put in the contract, and he has to understand what you are saying. For example, we had a recent transaction, and merger and acquisition transaction involving guys from Russia and also from Switzerland. When we were drafting the contract, it was very difficult because the guy who was speaking from St. Petersburg, he was a guy, the only guy, I'm sorry, who spoke English. So we have to translate him from Spanish to English. So in order to him to explain his board of directors in Russian and to put all the wording in Cyrillic, it was a nightmare. You may imagine that. So helps a lot to put the contract, or discuss the contract and all the terms in the contract in one language. That helps a lot. Be sure that that one language is the one language that controls the whole process, and of course the wording of the contract. That should be discussed from the very start. Don't try to advance in two languages and then switch to English, because that is very difficult. Is most recommendable from the start to agree in one common language or in a lingua franca like English, for example, and then advance in the contract. Make sure that there is one or more language, and if there is one or more language, make sure that you have one controlling language. We lawyers have normally reserve a clause in the end of the contract to make sure what is the only contract that is going to control the possible discussions or the interpretation of the agreement. We recommend that a lot. Next slide, please, Jeff.
Sure. And just one or two quick comments. One, when you don't have an agreement on just one language, which occurs sometimes, it's helpful then, in my experience, is to have side-by-side languages, but the key, as Diego mentioned, is to make sure it's very clear that one of the languages will control. And then even when you don't have multiple language issues, just the art of what words mean. I've done trials where there were key agreements that were in French, and another one, key terms in Korean, where everyone thought they had certified translations of what those terms and provisions meant going into the trial. In the middle of the trial, you get another interpretation, translation by somebody, and all of a sudden in trial you're dealing with a third meaning when the two parties had maybe different meanings among themselves to begin with. And if you knew beforehand how to avoid issues of language where the language may not be that clear when it's translated into whatever language may be where you'll have a dispute heard, would save you a lot of grief and time, and certainly avoid vagueness and uncertainty, which is what no one wants when you're entering into an international transaction.
Yeah, can I just come in there as well? There are also nuances even between English documents. You could have a document created in the UK, and you could have also English-speaking Americans, and there can be differences in interpretation even within English-speaking areas. So that's another factor. Don't just think it's straightforward. Even when people speak perhaps one language, it could be the same in Spanish to some extent.
Oh, even very clearly what the word now in Spanish may mean completely different in Mexico versus Spain, I know from experience. And then cutting corners sometimes are necessities of translation. I've had a case once where I was starting with source documents that were court documents in Mexico. Had to have them translated in English because English speaking was part of it, and then also Korean, and finding translators who could translate Spanish to Korean, very difficult. Finding translators in the circumstance I was involved in who could then take the Spanish to English and then take the English and translate to Korean, easy. And of course, how much is lost when you do that type of exercise of translating and then translating from a translated version? Who can tell? So issues to be thinking about, and again, the best would be one language everyone agrees on, and then just trying to avoid ambiguity and cultural ambiguity and so on. We're next going to go through what each topic could frankly be that we're going to be seeing an hour or more of a whole separate webinar. But if you have a dispute, you want to know ahead of time what would actually happen if the dispute arose, and what will each side be thinking about from their perspective of what may happen when they gauge how they perform under an international transaction. If you had to bring somebody to account for not performing under the agreement, or to get a specific performance of an injunction or an agreement, or to protect trade secret information being shared among the parties. So we're going to cover very quickly from the U.S. perspective, the United Kingdom and EU perspective, European Union, and in Paraguay and Latin America, these type of basic issues. And we're going to cover, and again, we could very briefly, but enough hopefully where you'll know the issue, so at least you'll understand it and see it and think about it from the beginning rather than learn about it later when there's a problem. Venue and why that may be very important as to what you want to control when you're structuring your international transaction, the choice of law issues that you can agree on in your transaction from day one, how to anticipate what each side will think of their accountability, meaning if you had to go to a court, which you don't want to, but if you had to go to a court, what will the other side be thinking of whether or not it'll have any meaning if you got a judgment against them, whether the judgment be recognized and enforced where they have assets and so on. Similar issues as to maybe arbitration being different, and then the mediation issues to avoid a dispute going to court or an arbitration. So Peter, we'll start with venue.
Yeah, dealing, as I say, with the first of your points, Jeff, about venue. Again, this is an issue that should be carefully considered at the outset. It may seem obvious, but each party to a contract would usually prefer to have disputes resolved local to them. But how would you control this? Alternatively, from a tactical point of view, some parties may want to make a dispute more difficult for the other party. They may want to choose venues with complex legal systems, or where there could be delay and difficult enforcement issues. If, say, a UK company has the greater bargaining strength, it may want the issues dealt with in the UK jurisdiction and the UK courts. The way to deal with this is to ensure that it is made clear and agreed within the contract. If there is no contractual agreement for the venue, these issues can become very technical, and each jurisdiction may have its own tests, which may include consideration of the residence of the parties where the contract was completed or performed, or perhaps where the damage or loss occurs. These arguments can become very technical and costly for the parties to resolve, and it also adds an element of uncertainty. Looking at it from the UK perspective, in advising a UK client, even though probably each of the three of us may feel the same way about our own legal systems, one always would prefer to use your own local legal system because of its familiarity. We are all mindful of the reputation of our own legal systems, and almost certainly one would want to consider cost implications, and particularly whether the costs of any dispute can be recovered. However, if you can't agree on the venue, the way around this is to seek to agree a neutral venue. But again, this comes down to having a clear understanding of the legal implications of that neutral venue. And this is all the more reason why you should take advice from lawyers in those locations. One can have dual jurisdiction clauses, where the parties can bring an action in different jurisdictions, depending on who initiates the proceedings. However, there may be arguments whether such clauses are interpreted as exclusive or perhaps non-exclusive. I think, Diego, this is where you want to take this a little bit further.
Sure, and
Yes.
just to make sure those, and I see this frequently, by the way, when parties can't agree to try to avoid disputes, they think, I know how to solve this problem between us since we can't agree and nobody has control of the agreement because they have all the power in the transaction. And that is the party who wants to initiate a dispute has to sue the other party in their home turf, which is presumably not as friendly, and vice versa. And sometimes that works, sometimes it doesn't work, but it's certainly one of those strategies to consider.
Yeah. Thank you very much, Peter and Jeff. So continuing with the venue issues, especially where do you want to resolve your problems? I think you should consider the following for Paraguay and applicable in most countries of Latin America. The first question that you should address is your home turf versus their home turf. You have to check for basic rule of jurisdiction. Paraguay, as well as most of Latin American countries, follow the in rem or in personam basic rules for consideration. That is coming from the continental system adopted in the continental Europe. In a very simple example, if the object of the operation or the transaction is a real estate, and if the real estate is located in Paraguay, it is recommended to bring the lawsuit in Paraguay since it's closer to the object of the possible dispute in the future, and of course you will be very close to the courts in order to bring injunctions and other kind of procedural remedies. Except for Brazil, another issue to consider that local financial markets are not as much as developed as in the US or in the European Union, for example. That is except for Brazil, Mexico, and Chile that have very developed financial markets, and in those cases, you may leave the operation or the transaction in those countries. Or if you have another kind of developed markets in certain areas, then you will have no problems because the courts are already trained in addressing these kind of issues, treating and of course adjudicating in this kind of operations. Another or any other jurisdiction issues to consider. First, it is difficult to say, but it's a reality. In the lots of countries in South America, with the exception of some, of course, local courts are easier to influence and slow to dictate judgments. That is a reality that the counselor have to take into account in order to consider where to have your jurisdiction once the dispute arises. When possible, to avoid this, we would recommend to resort to arbitration. Arbitration is being developed in lots of countries in Latin America, and as you will see in early or later stages of this presentation, most of Latin American countries have already adopted the treaties that accept or permits the enforcement of arbitration awards in most of Latin America. So when your dispute arises in the transaction, it is very helpful that you consider having your arbitration in another neutral country or a neutral location, and that takes to the next and final point of this slide. It's very recommendable to have a neutral location. Arbitration law in Paraguay, as well in other countries of Latin America, permits parties to resort to arbitration with arbitrators seated in other countries or other locations. It is usual that when a neutral location is agreed among the parties in a transaction, the parties refer, not to Paraguay, of course, we are meaning about the neutral country, that parties refer to Uruguay, Buenos Aires, or other locations in Latin America. Santiago and Lima are also venues or locations of preference to the parties. For example, Lima is preferred by parties in mining contracts or in oil contracts because the laws there are very much advanced, and Lima and Santiago de Chile have very advanced legislation of course, judges trained in mining issues. When choosing your neutral location and the seat for your arbitration tribunal, you have to be sure that your counselor checked for the New York Convention of 1958 for the enforcement of the awards. That will, in your strategy, consolidate your positions once a dispute arises.
And the venue issues that Diego was covering would be applicable in the rest of the world too, because obviously there's going to be huge differences between different countries' legal systems if you're going to a conventional court and not an arbitration. Are you in a venue that you pick where access to courts may be easy? Maybe the courts will be independent. How long will it take for a court to actually render a judgment, and will that be something that you wish you would have known long ahead of time? Will it be something where within 6 months to a year you'll be able to get access and get a judgment, or will it be a process where it'll be many years, 5 years, 10 years? All things to be thinking about long ahead of the time. And then similarly, in the United States, each state has its own legal system. Each court within the state has its own timing and system. And what type of costs will they have? I will note that if you go to the CONSULEGIS website, which is earlier linked on pages, you'll see that one of the recent newsletters of the International Litigation Arbitration Specialist Group was just a collection of articles on the court costs of different countries, and in the United States of different states, because those are important to know when you're structuring an international transaction. And our upcoming issue, by the way, will be on recovery of attorney fees around the world. Again, an issue that is important to have in mind when you're structuring your transaction so it plays out the way everyone intends.
Yeah. Yeah.
I think, Jeff, one of the key points that we have to consider in terms of neutral location is ensuring that you take advice from your colleagues within those jurisdictions to make sure that you know exactly what you're facing, and that's must be one of the primary considerations when looking at that point.
And I will note that my experience is the changes frequently, meaning what was yesterday, literally a month ago or a year ago, may not be the experience today in a local court, where maybe it was very slow, maybe it was very fast, and it could be very different based on political regimes, based on changes in the law, and based on budgets of the local court system. And you'll find that what you thought would be the type of form you'd want would be different. And we'll be covering in a moment, but it's a significant issue for venue in part, is if you need provisional remedies like an injunction to prevent the misuse of trade secret information that was shared as part of an international transaction, are you going to be in a venue where the choice of law that would control will be honored, and whether or not you could even get a provisional remedy, whether it be from a court or from a arbitrator. So we'll be covering those issues in a moment too, but all issues to be aware of, so at least your eyes are wide open when you're structuring international transaction, so that you're in control of all these points and not later on wishing that you were aware and had thought about them.
Yeah, yeah. So going to our next slide. Thank you very much, Jeff. We are continuing about the venue issues because they are much issues to take care of here in this part. If you are making a strategy, you have to consider first if there is a favorable forum for different parties. In this case, I think also is very important to take care or to consider the reputation of the courts that you are considering of. If as I was mentioning before, courts in my country, in Paraguay, or some other parts of Latin America are influential, and that is an issue or a matter that have to be very much taken care of in drafting your venue clause. Also, the issue of specialization. If the courts are going to be understanding the matter or the subject matter of the transaction whenever the dispute arises. Also, very important to take care of is where the assets are located. If the assets are located in different venues, of course, you have to consider the possibility, even though the tribunals or the courts are not reliable, you have to consider the possibility or the chances of having your dispute there because the assets are located in that venue. That makes it very easy, for example, to bring the lawsuit in that court, to get injunctions, because the subject matter or the asset that you want to seize are located in that venue. The second, which of the parties is more likely to have a dispute and want a contract to be enforced? This is a must. If you have a party that you feel that is prone or is likely to getting you involved in a dispute, it is very important that you make a strategy for you that to look for a neutral court. Don't take any chances, because if you feel that that party is going to during the transaction or during the progress of the transaction is going to jump easily into a dispute, make yourself very sure that you take or you go to a neutral court or a neutral location for your arbitration. What is the substantive and procedural law that could be applied in the chosen venue? This is very important, and you have to make sure that your counselor takes very much into account, because the procedural law that finally you choose, or the substantive law also that you finally choose, will determine your jurisdiction. And if, for example, you have an arbitral tribunal sitting, for example, in Santiago, Santiago de Chile, of course, the procedural laws of Chile will apply for the eventual appeal of that decision of the panel of arbitrators. So make sure that the laws, the substantive laws of Santiago of Chile and the procedural laws of Chile are laws that are going to address the dispute in the way that are in line with your objectives. Because if you get stuck, once you get stuck with that procedural law, you advance and you will make yourself, you will end up with endless revision of your arbitration award. The fourth, I'm sorry.
Oh, I was just make the comment that to add to the issues to be thinking about when we say arbitration versus litigation, you need to be also cognizant of the likelihood of, if you pick arbitration, whether the arbitration will actually be mandated if it's disputed by your local court that you pick.
Yeah.
Because you may pick a place that just doesn't like arbitration, and notwithstanding your agreement, you may not easily find yourself in the arbitration that everyone agreed to.
Yeah.
And again, maybe the other side knew that better going in than you did.
Yeah. It might be a tip for the audience that lots of countries in Latin America adopted the UNCITRAL uniform law that also and for example in Paraguay we adopted the UNCITRAL model law, and that is very easy for counselors, let's say for example in Germany, to review the law, because the UNCITRAL issued a common law that was introduced by Paraguay. So when I am checking the law here and also the possibilities for appeal, a counselor in Germany is going to be checking the same law. Paraguay internalized that UNCITRAL model, and that is very easy to follow because it is an uniform or very uniform law to follow.
UNCITRAL is, by the way, the United Nations
I'm sorry.
Commission on International Trade Law, which formulates and regulates international trade and cooperation with the World Trade Organization, just for those who don't know what it means. And as an interesting aside, California has a International Arbitration Act that actually follows the UNCITRAL rules, which is not the typical thing in the rest of the United States as to foreign rules being literally in the statute.
Good, Jeff. And if you are checking, if you are following with me the same transaction, and if you check the laws of Paraguay, or I'm sorry, the arbitral laws of Paraguay, you are going to be checking the same rule.
Okay, let's turn to forum selection provisions. Just a couple quick things to pick. So what do we mean by that, first of all? So your contract provides, or you want to provide at least, what your pick is, where the forum would be, where the venue would be. So then the question is, when you choose that venue, that forum, and when you choose what law controls, which we'll talk about in a moment, how likely is it that the court will actually enforce your pick of venue when there's a dispute among the parties as to where to have the dispute heard? I will share that in the United States, we have a Supreme Court case that's quite clear that forum selection clauses are prima facie valid when included in a freely negotiated private international agreement in the type of international transactions we're talking about. And maybe a quick, do they work similarly or different in the United Kingdom, the European Union, and in Latin America? So let me ask Peter and Diego quickly.
From my point of view, I was going to come on to that when looking at forum and choice of law. If I then just come in at this particular point, if I'm looking at European rules and regulations, in dealing with these questions, which we could deal with as venue, jurisdiction, and choice of law, and in particular in the UK, we would perhaps look at traditional or common law rules, and specifically whether the issues in the dispute provide a sufficient connection with England, and that it is appropriate to start proceedings in the UK. Under the European regime, this comprises various European regulations and conventions, but I think I have to mention the principal one that I think is taking effect since January 2015 is the Brussels recast regulations. And very quickly in dealing with that, it deals with the scope and application of jurisdiction agreements, the interaction between exclusive jurisdiction clauses, and the what is known as the lis pendens rule, where parallel proceedings are brought in 2 or more member states, and rules considering the involvement of non-European member states and enforceability of foreign judgments in a member state. All of that could be the subject of its own webinar, and it'd be very difficult to go into the detail of that in any particular detail. But this is pretty much the forum within Europe as to what would be the guideline for dealing with many of these issues.
And anything to note in Latin America, Diego?
Latin America is very mindful about public policy for considerations. For example, if you choose during the choice of law, if you chose, for example, a UK law, let's say, and if that decision of the arbitrators contravenes public policy considerations of Paraguay when trying to enforce that arbitral award, you will be stuck again into a problem, because the courts in Paraguay might refuse to apply or to enforce that arbitral award on grounds of public policy considerations. So when checking that, you have to be careful or mindful about that.
Okay, Diego, you want to continue with choice of law issues?
Yes, thank you very much. I'm sorry, I didn't see it. So also, it's very important to have or considering in your strategy to know about the difference between the possible laws. That requires a research in advance, and preparation in this matter is important, because you have to let your counselor know that which are the parties that are going to be involved, which are the countries that are possible to be involved in the transaction, and give him time to prepare for the possible or likely scenarios that he's going to be involved, and in the research he's going to do all that. Also, in this part, it's very important to consider or consulting with local counsel in the foreign country. In this matter, I think CONSULEGIS is very important, because our net, and I resort to our net in every time that I have different countries involved in the transaction, because it gives you the opportunity to consult with a local and reliable counsel in the laws that you are going to, or in the subject that you are going to be dealing in your transaction. And consider again, who is more likely to have a dispute. Again, here you have to be attentive, or who is the party that is, I will call jumpy, or I will call more prone to be involved in a transaction, and consider the neutral forum to avoid such kind of conduct. I don't know if Jeff or Peter want to add something on this.
I think we covered the point of, just thinking through, and again, you need to deal with somebody who's familiar with the local court system, or what you actually put in the contract to actually play out. I recently had a case where it was a contract where it was under German substantive law, venue was in California, and the other side, I was representing the plaintiff who was asserting a breach of a licensing agreement that was under the German substantive law, was trying to convince the court in California that how could they apply German substantive law. And of course, that was not a problem. And then the issue, which wasn't as clear in the agreement, what German procedural law versus California procedural law would apply to different issues such as prejudgment interest. So you just need to think these things through, including the likelihood that a court will honor what the parties put in the agreement. So that's sort of the takeaway points probably for everyone.
Well, again, from my point of view, it's a pretty similar one, the consistency between a governing law clause and a jurisdiction clause. So, for example, if you wanted a dispute to be resolved in English courts, choose English law. You want to match the choice of law with your forum. Otherwise, for example, expert evidence on the nuances of the law chosen will be required. The typical situation or an example that you could use, would it be sensible to use French law in English courts, as we then need experts in French law in order to assist, and that would be totally illogical. So again, this just further emphasizes the thought that needs to be put in at the outset to ensure that there are no ambiguities of that nature.
And I'll just share, in the United States, it comes up frequently, and the concept of the manner of how you present a foreign law, which controls by the agreement of the parties, assuming it's being honored by the court, is actually usually not that unclear, and it's not that unusual to present foreign law experts, or in the case of, I think off the top of my head, France and Germany, a lot of their basic contract law are officially in English. They may not be translated correctly, but there's an official version in English that's available on the internet. Makes life a lot easier if you're dealing with just basic contractual terms. So now we're going to quickly touch on the issues that you should be aware of. We've been touching on these, but we haven't discussed them yet, which is litigation versus arbitration. If you don't put in arbitration in an agreement, unless the parties later agree to it, the default will always be litigation in some form, meaning some venue in some place in the world. And it'll be, hopefully, if you picked a choice of law as to what law will govern, and you didn't leave that empty, which happens sometimes, so it's not in the agreement. So we're going to cover what does it mean when you have an international dispute and it goes to litigation, and then we'll compare that to what happens if you chose arbitration and see why in certain circumstances you may want to pick one over the other. And we've touched on this, and you've heard Diego make the comment that arbitration in his region of the world works better, and I think you'll hear that that's for an international transaction only, maybe a shared view, but we'll get there and explain it so you'll make your own determination and at least have your eyes wide open so you know the issue and you could be intelligent about it when you structure your transaction. So litigation may involve discovery, and being the one from the United States, I know the rest of the world often is afraid to have venue in the United States because they think, well, the courts are very independent and the courts may be very professional and work, that the process will be incredibly costly, and a lot of it becomes discovery, since the rest of the world doesn't have discovery as we do in the United States. And what I mean by discovery for our non-U.S. familiar participants on the webinar, we have the right to take depositions and get sworn testimony under oath where people answer live questions outside of the court before trial. We have the ability to ask people questions, interrogatories in writing that they have to then respond to under oath. Similarly, it's a system where it's anticipated that all documents will be potentially obtained by each side as long as they're somehow, in the broad sense of the word, relevant to the dispute. And relevant in the United States is maybe much more broad than anyone else would think, because it may just tend to lead to information that would actually be used at trial. So it's very broad, and I know a lot of people get scared by that because it's invasive, they're not familiar with it, and so that's an issue to be thinking about, because discovery some places doesn't exist, or it's very limited, and you don't produce documents that are hurtful to your side, to your opponent. Some countries you have juries, like the common law countries, maybe Japan's starting to have them more. Many parts of the world, the concept of a jury is far from ever happening. The speed and cost of litigation, depending upon, as we mentioned earlier, it may become very expensive and very costly, depending on how long the proceedings last or how quick the proceedings will be. We touched on earlier, too, if you need a provisional remedy like an injunction or other prejudgment remedies, maybe attachment of assets to secure assets in case you get a judgment, and how likely they'll be enforced. You need to think about those. In litigation, they're more likely in most parts of the world somewhat established and tested, and at least you'll know the answer. When we turn to arbitration, you'll see it's a little different. You also want to make sure that when you're dealing with litigation, that you have courts with the tradition of being independent, as we discussed. And then, of course, in many parts of the world, if you have litigation going to a court, you may have, and so you want to know the answer to this, a right of appeal, so you have a second-level review, and then some finality to the process rather than just open-ended dispute resolution with no end in sight. So these are all considerations to be thinking about with litigation. And on the other hand, arbitration, we'll turn to Peter to go over sort of the key issues of arbitration.
Right. So,
and we're talking about international arbitration right now, not domestic, meaning arbitration between parties from more than one country.
Okay, so I'll deal with this from the arbitration perspective. Again, generally the principle of arbitration is that the parties can agree to resolve a dispute by the instruction of a specialist or an expert arbitrator whose appointment is to some extent within their control. It is often thought that arbitration is faster and cheaper than litigation, but certainly it's not always the case. Arbitrations themselves can take many months or even years to conclude, but it could be possible to create a time frame for the resolution of the disputes which can be agreed between the parties. But don't always assume that arbitration will be cheap. In some instances, the cost could be far higher, and certainly in many international arbitration cases, that could well be the experience. An advantage is that arbitration is usually dealt with privately, but there are instances where, again, where they can become public, certainly if court intervention is needed at some stage. Perhaps if there is some injunctive relief that might be needed. As indicated, there is no jury within the arbitration process, and I would probably say from the UK perspective, in commercial cases, there's no jury in litigation process. In relation to formalities, they are usually less formal than litigation. Strict rules of evidence generally don't apply, and of course procedural rules will be more often based on the institution that the arbitration process is brought in, and we'll come on to that a little bit later. In relation to discovery or disclosure, particularly from the UK perspective or European perspective about the disclosure of documents, depending upon the rules applicable to the arbitration organisation involved, discovery or disclosure may not be required to the same level as perhaps it would be for litigation. The advantage of arbitration is that it can be customized, the parties can control the choice of arbitrator, language, time, venue, the law, and of course procedural rules. Remedies are a little bit more restricted, but arbitration is much more restrictive in dealing with things such as injunctions, security for costs, and as stated, less adherence to the strict rules of evidence. The outcome is binding. There is also certainty in getting an award at the conclusion of an arbitration, and generally arbitration awards cannot be appealed. It must be said, however, that parties are usually happier with the decision of an arbitrator because of the specialist expertise and knowledge of that arbitrator.
And I'll make a comment, as Jeff, that if it's not, and we'll see in a moment why I say this, if it's not an international transaction, I actually favor dispute resolution in a court in the United States over private arbitration, because there are more checks and balances. Arbitrator makes a decision, there's very little you can do about it. Even if they misapply the law, they make the effort to apply the law, even if they do it wrong, or they make a factual decision that has no support, very tough to challenge. And you can build, by the way, because everything's customizable, you can build into your arbitration an appeal process by other arbitrators, and there are some tribunals who now sort of offer that, but again, limited value probably as to actual checks and balances like a court and a court of appeal would be in a country. Other considerations when choosing between litigation and arbitration we're going to go over, and this is sort of what makes international arbitration versus domestic arbitration different in my mind, and that is the likelihood that a resulting judgment from a court or the award from an arbitrator will actually be predictably enforced and recognized in other parts of the world. And this is where arbitration, litigation, and an international transaction completely are different in large part. Enforcement of judgment issues. So this is, of course, not an arbitration from a court. You need to give consideration right up front when you're structuring your agreement, if you don't put an arbitration, where you would likely, if you get a judgment, want to be able to enforce it. And what I'm referring to, just to make it clear, is let's assume that the venue was in New York. And I have a judgment from a New York state or federal court. And the other party has no assets in New York, or has most of their assets in, we could pick anywhere in the world. We'll say Paraguay, since we have Diego on the phone. And then we also have assets in the United Kingdom. So that judgment's not going to have much value to me from New York if it won't be recognized and enforced in Paraguay where there's assets, and whether it would be enforced and recognized in the United Kingdom. There are, with the United States, no treaties that at the moment deal with recognizing and enforcing judgments around the world. There are protocols, and they differ in the United States by state even, so it's very something you have to look at, but there's no treaty, so there's not a lot of predictability. And I will tell you from experience that having eyes wide open for parties, knowing that a judgment obtained in the United States was going to have to be recognized and enforced in another country, and having local counsel involved ahead of the litigation even starting to get the judgment, trying to do everything as perfect as can be, it doesn't always work, because a lot of countries will protect their own when it comes to foreign judgments and find issues that are hard to predict, that may not even be fair issues, as to coming up with reasons not to recognize and not to enforce that judgment that you spent so much time for. And if sometimes the other party, when entering into the contract, sort of knows that may happen. And if you aren't aware of what they're thinking, your transaction may not play out the way you intended. And similarly, as to the same thinking as to, if there's a judgment in another part of the world, you want to know ahead of time, do you believe it's likely or not, and what type of roadblocks and obstacles there may be thrown in, or you could throw in if you want to avoid the foreign judgment being recognized in where you have your assets. And it's very key to consult with a foreign lawyer to make sure you understand these nuances, or you'll be just rolling dice no matter how good your agreement reads as to what it will play out and what the other side may even think when they sign the agreement, meaning they'll think that what they're agreeing to has no meaning because they'll never be held accountable by a judgment anywhere. And the reason why arbitration awards are different is, Diego mentioned this earlier, we've had since 1958, so we're talking about an extremely long time in the modern world, an international treaty that provides a standardized, agreed upon measures for when an arbitration award in an international arbitration, parties from more than one country, would be recognized and enforced. So there is great predictability compared to zero predictability sometimes for judgments as to how a foreign arbitration award may be treated when you go to another country to get it recognized and enforced as a judgment. More than 160 nations have adopted the New York Convention, which is virtually anywhere you could ever probably be doing business. And the only major industrial country that has not adopted is Taiwan, but they have adopted their own means to make recognizing and enforcing of arbitration awards more predictable. So in the context of international arbitration, while I personally am not a fan of it for a domestic, meaning an internal United States dispute, for example, when it comes to international arbitration, I lean towards supporting it because it's the one dispute resolution that will actually have meaning virtually everywhere in the world. And that is why for an international transaction, it makes a lot of sense to agree on arbitration versus different possible courts. And Diego.
Good, good. So all the considerations that we were making are coming to the final drafting of the arbitration clause. So when we are thinking about which organization, arbitration organization we are considering, here in Latin America is very important to consider the reputation or the reliability of the arbitration organization, because local courts, when enforcing the judgment, pays a lot of attention about the arbitration organization. If it comes, for example, from the ICC or from the ABA, the arbitral award, if it was administered, but one of those arbitration organizations, local courts tend to be much easier to grant the enforcement of the arbitration award. Also, in terms of costs, it's very important that you take care of the cost of the arbitration organization. Some are much expensive than others. For example, ICC and the venue, if you are going to have your arbitration panel in Paris, of course, is much more costly than having an arbitration, let's say, in Lima or in Santiago or in Buenos Aires. These are much closer for us venues, and of course much cheaper. And if you are speaking about the which arbitration rules, again comes the reliability of the arbitration organization. The test of time of the rules of, for example, let's say the ICC arbitration organization or the London Court of International Arbitration, the test of time to this organization gives a lot of certainty to the party who is going to think about arbitration. So in our point of view, or in our mind, we take a lot of consideration on this. On the third issue about the venue issue and choice of law issue, we were discussing this in previous chapters. Consider the venue where your arbitration tribunal is going to be sitting or is going to be located, because that venue will determine which procedural laws are going to be being taken care of. For example, when enforcing a provisional measure, let's say an injunction, or the rules of appeal or the control mechanisms to control the arbitral award. If your venue is located in Santiago de Chile, as I was mentioning in my previous example, the procedural rules of Chile are going to be affecting the outcome of your arbitral award. The courts of Santiago are going to be reviewing this arbitral award, so you have to be mindful about this. Finally, the numbers of arbitrators and the selection process. Be very attentive about the language of the arbitrators. If they speak the language that your transaction is going to be or your contract is going to be drafted, if they have the specialization and the skills that you are considering in your transaction, you have to be very mindful about this when you are selecting the arbitrator. And the numbers, of course, that depends a lot on the arbitration rules that you select. Peter or Jeff, you want to add something?
Sure, and just a quick comment. I once had a client in the United States, English speaking, who had a contract that was in both Spanish and English, Spanish controlling, but it was side by side, 2 columns. Venue for disputes was in Madrid, Spain, arbitration, the Court of Arbitration in Madrid, and it did provide that the arbitration would be in English. Very important to my client, since my client really did not have Spanish language skills. Lo and behold, the arbitration was being conducted in Spanish. And so I would have to draft documents in English and have them translated into Spanish, even though the agreement provided expressly that it was to be in English. Things to think about. There's more to the story than that, but just to give like type of things to be aware of to try to do your best to avoid surprises. Peter, anything before we go to mediation?
No, because I think we're probably running out of time, so I think we probably should move on. In touching on mediation pretty quickly, mediation is now becoming more common in trying to resolve domestic and also international disputes. It always seems sensible in agreeing contractual terms to consider the insertion of a mediation clause. So why would you do so? The advantage is that it demonstrates that the parties are trying to operate in good faith and to work together to resolve their differences. If one resolves a dispute by mediation, it often preserves the business relationship between the parties, where often more in arbitration or litigation, the professional relationship between parties is more often than not destroyed. In the UK, there is a strong leaning to force parties towards mediation before litigation or arbitration, and sanctions could be applied by the courts to the parties if they have failed to do so. Mediation involves the services of a third-party mediator who will not seek to make any decision in favour of either party. One must remember that all a mediator will do is to attempt to help the parties negotiate a settlement. But the advantages of mediations are that they can be organised very quickly. Costs are often much lower than other dispute resolution methods. They take place in private and are usually very informal. Parties are more often in control of the content and the outcome. And a big advantage is that solutions can often be more flexible and creative than via litigation or arbitration. For example, you can't underestimate the importance of an apology or perhaps an agreed statement publicly made regarding the dispute. Therefore, for these reasons, mediations should be one of the main considerations for the parties.
So in summary, hopefully we've covered many areas, but out of these areas, even if you're very experienced with structuring international transactions and dealing with and managing disputes, there are things that will give you areas to think further about. A lot of these topics we could spend, as I mentioned earlier, an hour on each one, so we're just sort of giving you enough information so you can spot the issue. And I think the most important thing is to say, take these tools we've given and issues and take control when you structure your transaction, and then how you also manage if you have a dispute, so that you're in control. Be creative, make the deal that you're doing work as best as possible for your side, make it as clear as possible, and hope that if you do all of these things, you will at least have done your best to ensure that whatever the transaction you contemplated will play out the way you intended. And in the event of a dispute, you've contemplated and strategized ahead of time what will happen so that it works as best as can be for you, and hopefully to avoid the dispute in the first place. And with that, thank you very much to everybody.
Thank you, Jeff and Peter.
Yes, thank you both.
Yeah, and thanks a lot from my side to Peter, Jeff, and Diego.